Hey everyone, it's Layla Shaver here with another episode of Case Study Wednesdays. So today we're going to be talking about in the matter of ARIA Partners GP LLC. That's administrative proceeding number 3-18657. So at the time that the SEC came and did an investigation of ARIA Partners, they were a Delaware LLC that was registered with the SEC. So ARIA Partners GP, as you can imagine, that stands for General Partner, and managed several different funds. And one of the issues that came up with one of their funds is that there wasn't a consistent redemption policy. So their official policy was that you had to give 90 days written notice for redemption, but they also had an informal policy that allowed partial redemption, and in the case of a number of investors, a full redemption with 60 days notice. However, these informal policies weren't communicated to all of the investors in the fund, and it wasn't in any sort of written documentation that had been previously provided to them. So as a result, there wasn't a consistent application of that redemption policy, and as a result, a couple of these investors redeemed at a value that would have been greater if they had been redeemed at the time they made the request. So for example, they did a shorter term 60-day notice, and they were told that you could only do it with 90-day notice. And what happened is that 30-day period, the value of that fund actually decreased. So at the 90-day, the value of the redemption was less than what it would have been if the 60-day had been honored. Also, they found that the RIA had compliance manual policies and procedures, and they had them as of 2004, but it wasn't tailored to their business. They didn't conduct annual reviews of the policies and procedures, so as their business grew and changed, the policies again at first were already not tailored, and then became more and more outdated as time went on, as they grew and their business model changed. Also, because they were managing funds, a lot of funds are deemed to have custody of client fund and securities, so they're required to have annual audits. They failed to have annual audits of their funds. They also made inaccurate statements regarding their assets under management. So their assets under management was actually materially less than what you needed to be SEC registered. So they shouldn't have been, but continue to renew every year as being qualified to maintain their SEC registration. So ultimately, what happened? They were censured. There was a cease and desist, and they were also forced to pay a civil penalty of $150,000. Now you'll notice I mentioned earlier that two of the investors received a full redemption at a value that was lower than what they would have gotten if the redemption was done sooner. Well, one of the punishments, so to speak, was not to make those investors whole or to pay them the difference. And this, for me, is an example of where regulators are going to ensure that you're going to pay a fine. In such an incident, they're saying you did something wrong, these investors potentially lost money, but the punishment is a civil fine that gets deposited into the U.S. Treasury. So for me, this is a good example of where client harm was alleged, but the punishment wasn't to make the client whole. So $150,000 is a lot. As many of you know, the AUM to be SEC registered is generally $100 million in AUM, and they had a significantly less amount in AUM. So $150,000 fine is significant for a smaller firm that would otherwise be state registered with a state regulatory agency. Also, this is another example of why it's so easy to get in trouble with regulators for something as simple as not updating your compliance manual, doing an annual review of it, and also not recognizing the fact that you have custody and all the requirements that come with having custody. And if you do have custody, if you're subject to any of the exemptions. So for example, if you have custody solely because you deduct your fees automatically from the client's account, there's exemptions to that surprise audit requirement. So, and those exemptions, are going to be based on your state, what extra protocols you have to put in place in order to qualify for the exemption available. So, really important things to know. Talking about funds, be aware of custody. Regardless of whether you only manage funds or only manage separately managed accounts, make sure your compliance manual accurately portrays your business practices and that you keep up and update your compliance manual and that you have documentation that you've done your annual reviews. Inaccurate statements, these are filings that you make every year on at least an annual basis during your annual amendment. So there is going to be documentation of these inaccuracies, and it's one of the first things that examiners are going to look at, and it's the easiest way for them to find a mistake and try to fine you for it. Also, I've run into situations where we've, represented clients who were SEC registered and shouldn't have been and had to go register with the state. Sometimes they give you the benefit of the doubt and there's no fine associated with it. But sometimes in this case you are. So if you're unsure, you're having problems with accounting, we have a CFO consultant on staff who can help you look through your financials, look at your client files, and really help you figure out what your AUM is if you are unsure or if you're having problems figuring it out. So, compliance problems, give us a call. Now's a good time to do a mock examination. A lot of these state regulators and the SEC did training over the summer. It's kind of like police officers and ticketing. Like all these cops are trying to ticket you towards the end of the month to make their quota. Well, we're getting into, believe it or not, the end of the year and going into, fourth quarter. These examinations are going to ramp up. They're going to try to make their quota for the year. So come in, get your mock examination done. Let's see what's going on in your firm, what you're not doing, and let's fix it before you too face a civil money penalty of $150,000. So you can call us at 770-462-2118 or email compliance@myralawyer to schedule your consultation. Thanks so much, guys. See you next week.